I'm conscious of everyone's time. By my clock, we're 2 minutes past 9:30 a.m., so I suggest we begin. A very warm welcome to Howes Percival's Autumn Private Wealth webinar, Scratching the Surface, How to Protect Your Clients' Interests. It is great to see so many people on the call. My name is Tom Lawrence. I'm a partner and head of private client at Howes Percival. Today, we have an excellent selection of speakers from our private wealth team from across the country, who are Stuart Maggs, who's a partner and head of tax, Jennifer Lasky, who's a director in our contentious trusts and probate team, Rebecca Littlewood, who's a senior associate in our private client team, and finally, Justin Flack, who's a partner and head of the family team. The dynamic of families continues to evolve. At the same time, the wealth they own and control becomes more complex and diverse. Add to that the event of a death, and however strong relations amongst a family can be, some strain can be felt, and in some cases, there is an irreversible breakdown in relations. Next slide, please. As you'll see from the slide, it shows some examples of high-profile estate disputes, which only ended after lengthy legal cases, incurring significant professional fees, which might have been avoidable had good advice been taken. So on to today's case study. Next slide, please. The bottom of the slide shows quite a simple family tree, and you should have received a copy of this by email in advance of today. The protagonists in our case study are Barry, who is soon to marry Averil. Barry has one daughter, and Davina, and Averil has two sons, Everett and Emmett. When Barry's wife, Christabel, passed away, he became a trustee of her £15 million estate, as well as a beneficiary along with his beloved daughter, Davina. Soon after Christabel's death, Barry found love once more when reunited with his childhood sweetheart, Averil, whom he is about to marry. Averil's twin sons, Everett and Emmett, two ambitious businessmen, have recommended that Barry and Averil visit Howes Percival to discuss creating a joint will ahead of their upcoming nuptials. So before I pass you over to Rebecca Littlewood, who is going to take forward the case, from here, if you have any questions, please could we ask that you place them in the Q&A box, which should appear in the lower middle of the screen, and we will endeavour to answer as many of the questions as possible at the end of the presentation. If you have any particular technical issues, by all means use the chat function, and we will do our very best to help. So I hope you enjoy the webinar, and over to you, please, Rebecca.
Thank you, Tom. Good morning, everybody. So today I'm just going to talk briefly about wills, testamentary capacity and undue influence, which all relate to our case study. Next slide, please. So following on from Tom's introduction, initially we would have a meeting with Barry and Averil to discuss their wills. But in our initial meeting, Barry doesn't attend with Averil because at the last minute, Averil was unwell and couldn't make the meeting. So instead, Barry attends with Everett, Averil's son. Barry explained that Everett had encouraged him to make a proper will. So not an off-the-shelf job or a do-it-yourself. He wanted him to come and see us as Everett's an existing client and knew that we would give him the full advice that he needed. In the case study, you will have seen that Barry and Averil thought they needed a joint will. In fact, this is a common misconception amongst spouses who think they will have one document that covers everything for each of them. In fact, what is actually the case is that each individual would have a separate will, which we will explain to Barry. Usually, spouses tend to have mirror wills, which are identical or near identical terms, hence the name mirror wills. Alternatively, there are also mutual wills, which are not to be confused with mirror wills. They are very different and go a step further. So they are not only substantially similar in their terms, but each party would also enter into an agreement that the wills would not be changed. Now, we know that Barry and Averil are due to marry soon. And so when advising Barry about his will, it's very important that we cover the fact that if he should marry, a will would be automatically revoked under Section 18 of the Wills Act. This could, in effect, lead to intestacy, which are a very old set of rules, the intestacy provisions, which specify how an estate will be distributed on death with no will in place. So it's far better that we should preempt this, knowing the situation and knowing that Barry and Averil are due to marry, and we would ensure that we're drafting the will to include a special clause which is stating that the will is made in contemplation of that marriage and therefore would not be revoked upon the marriage. Next slide, please. So in order for Barry to make a will, there's several things that we need to be conscious of as the advising solicitors. Firstly, obviously, we need to make sure that Barry is over 18, which he is. He's in his later years. He needs to make the will voluntarily. So under no undue influence from another party or no coercion, he's got to be making this of his own free will. He also needs to be of sound mind, which I'm going to come on to capacity shortly. As well as those three facts, he also needs to ensure that the will is made in accordance with the formalities of Section 9 of the Wills Act. So the will must be in writing. It needs to be signed by the testator, which is the person making the will, so Barry in this instance, or by somebody in his presence and at his direction if he's unable to sign for any reason. And it needs to be signed in the presence of two witnesses who are both over 18, and the witnesses must sign in the presence of Barry also. Next slide, please. So in our meeting, before we even start to take the will instructions, we managed to gauge a bit more information about Barry and his situation. He explains that he and Averil are childhood sweethearts, and having come back in touch in recent times, they have decided to marry, and the marriage will take place in a few months' time. He hasn't had much to do with the wedding plans, he says, and actually Everett and Averil have been pretty much planning this together. And Barry was quite happy that that was taken away from him and he didn't have to think too much about it. As Tom said, Barry has a former wife, Christabel, who sadly died a few years ago. Christabel was very wealthy, worth in the region of 15 million, and under the terms of her will, there was a trust. Barry is one of the beneficiaries together with his daughter and Christabel's daughter, Davina, which was their only child. But when we're discussing the trust and Christabel's estate, Barry doesn't recall too much about this. As I say, Davina was the only child of Barry and Christabel. She lives in Exeter with her long-term partner, whose name Barry couldn't remember. So at this point, Everett takes over the conversation and leads it really, talking about Davina. He explains that Davina has been diagnosed with autism in later life following a difficult childhood where it was undiagnosed, and that they don't get on particularly well with Davina's long-term partner. Everett at this point explains that the reason there are issues with Davina's partner is that there have been rumours that Davina and her partner are wanting to buy a second property in order to run this as a brothel. To which Barry thinks this is absolutely preposterous and couldn't possibly be the case, but Everett insists that something is not quite right. We talk about the assets in Barry's estate and what he has. Of course, we need to ensure that we know what we're going to be dealing with and what he needs to dispose of under the terms of his will. Barry doesn't have too much detailed information. Again, this part of the conversation is led by Everett, but we know that his estate is worth in the region of £5 million. He explains that the reason he doesn't know too much detail about his estate is that Everett acts for him under a power of attorney and assists in managing his financial affairs. Next slide, please. So off the back of that initial meeting, there were some concerns with Barry's capacity. He was a little bit forgetful. He didn't have some of the information, and Everett spoke in detail about some of the points that we would have perhaps expected Barry to answer. It's really important with all clients that we consider mental capacity, but particularly with our older clients. NHS England estimate that around 850,000 people in the UK currently have dementia. Whilst there are other reasons that somebody's mental capacity might be impaired, dementia is a key topic that we need to ensure as legal practitioners that we are well aware of. And NHS England go on to say that the likelihood of developing dementia doubles every 5 years after the age of 65. So it is very prevalent. So as legal advisors, we need to make sure that we are assessing a client's capacity and that we are happy they have capacity before we take instructions. The leading case that mental practitioners look to when assessing capacity is the case of Banks and Goodfellow of 1870. The case states that a testator, so the person making the will, has capacity where they understand the nature and effect of a will, so i.e. that a will disposes of their estate on death and only comes into effect on death, that they have some understanding of the extent of the property they are disposing of, And the key word there is some understanding. So Barry knew that his estate was worth 5 million, and he could roughly tell us where that was. They don't need to know the complete ins and outs, but some understanding is crucial. They also need to be aware of the persons for whom they would usually be expected to provide, so family members and dependents. And they must be free from any delusion of the mind. Next slide, please. So as well as the test for capacity, the Banks and Goodfellow case also introduced the golden rule, where we are dealing or advising older or seriously ill clients. Now, the golden rule is just that. It's a rule and it's guidance only. But generally, for older clients, we will always make sure that this is considered. So the golden rule states that the will should be approved or witnessed by a medical practitioner, effectively to confirm that capacity was no issue. This could minimise or avoid disputes about capacity after death, which is what really we want to try and prevent. It's much easier to take action before the event. In order to comply with the golden rule, the will should have a letter, as I say, confirming capacity or be witnessed by a medical practitioner, but we need to ensure that that is a suitably skilled practitioner. And we would need the client's agreement to proceed with that, and we would need to ensure that we are meeting any timescales in terms of providing that evidence. What a solicitor can't do is delay the making of a will unreasonably whilst waiting for that evidence. And there have been cases where solicitors have been held negligent for failing to draft a will, and then the client's passed away in the meantime. Next slide, please. So after Banks and Goodfellow, we've also had the introduction of the Mental Capacity Act 2005, which came into force in 2007. The Mental Capacity Act, the purpose of this legislation is really to protect those who've lost capacity and to ensure that anybody working with that vulnerable person has a framework to use. The Mental Capacity Act introduces an assumption of capacity. So everybody is assumed to have capacity unless it is proven otherwise. And it then introduces another two-stage test for practitioners when assessing capacity. So the Act states that a person lacks capacity in relation to a matter if at the material time he's unable to make a decision for himself in relation to that because of an impairment of or a disturbance in the functioning of the mind or brain. So the two parts of the test are that firstly, number one, they are unable to make that decision, and number two, that is because of an impairment of the mind or brain. A loss of capacity can be temporary or permanent. So it could be temporary in the fact of an illness, an injury, where it's proven that they will regain capacity at some point. And capacity can fluctuate. So it's very important as advisors that we consider that. So we have 2 points of reference really for capacity. We've got the Banks and Goodfellow case, and we also then have the Mental Capacity Act. And often with legal advisors, they are looking to how these two interlink and which test we should be following. The general view is that the Mental Capacity Act should be used to complement the test in Banks and Goodfellow when assessing capacity. And recent cases have confirmed that that is still very much the case. Next slide, please. So a person is unable to make a decision under the Mental Capacity Act if they are unable to understand the information relevant to the decision, retain that information, use or weigh the information as part of the decision-making process, and lastly, communicate that decision. Communicating a decision needn't just be by talking, it could be sign language or any other means. And actually, I've had a client who suffered a severe stroke, occasionally could use his strongest hand to write notes, but other times it was a slight nod of the head or blinking once for yes and twice for no, and we were able to successfully take instructions in that matter. Next slide, please. So as well as Barry's capacity, we also have concerns about Everett's involvement in the making of a will. He's attended the meeting with Barry, he's provided a lot of the information, and he sometimes has spoken for Barry as well. We therefore have to ensure that we are considering whether there is any undue influence being placed on Barry to make his will. So undue influence is where a person is forced or coerced into making or changing a will so that it benefits that third party, putting the coercion on them. And undue influence is one of the possible grounds to challenge a will. If a will was challenged successfully on the grounds of undue influence, it would actually invalidate the entire will and not just the gift that was left to the person placing that coercion. So it's really important that, again, we consider this before the event and make sure that when we're taking those will instructions, we're happy there is no undue influence. Particular signs of undue influence may be changes unexpectedly or at the last minute, changes from any previous wills that have been made, changes that might be detrimental to the estate. So, for example, if they're making a particular change that causes a huge tax liability, we might have some questions as to why exactly they are doing that. And of course, other signs would be the illness or frailty or otherwise vulnerability of the client providing those instructions. Next slide, please. So how do we protect our clients, and how would we protect Barry in this instance? Well, firstly, we always like to see clients alone. Now, Everett has attended with Barry, and sometimes that's okay for the first part of a meeting. But when it comes to taking the will instructions, we would insist that we see Barry alone and perhaps ask Everett to leave the meeting room. We would obtain details of the family circumstances in the background, and this is full details, and we make no apologies for delving into your personal circumstances. It's really important that we have this information so we can advise fully. We will review previous wills and instructions, whether we've done them ourselves or whether the client's made a will elsewhere. We will always ask to see those documents. And we will, of course, make full attendance notes of all our findings so that if there was a challenge, we have some evidence there to use on behalf of the client. Thank you. Over to you, Stuart.
Hi there. I'm Stuart Maggs, Head of Tax, and I'm going to talk about a call I get from Everett. Next slide, please. So whilst things are going on with Rebecca and Barry's coming in, Everett makes a call to me and tells me that his stepfather-to-be is very wealthy, worth about £5 million, but there's a very valuable trust and the funds are stuck in the trust. It's really frustrating to Barry, he tells me, because it means he's got to deal with his wife's sister, who's the co-trustee, and she's very difficult to get hold of and very slow to respond to things. He wants to break things apart and try and regain control so that he's got control over his own assets and over his own life. The other thing is that his daughter, who is the beneficiary of the trust when Barry dies and due to inherit the whole lot, is in a difficult relationship. She's struggling to make good decisions in Exeter with a bad partner, and they're up to all sorts of no good down there. And Barry, I am told by Everett, is really worried about what would happen if she came into the whole amount of money in due course when he dies. They're also worried about tax, and so they ask if there's anything that can be done with this will trust that was set up by Barry's wife to try and improve the situation for the future. Next slide, please. So the first thing when I get this sort of call is to understand what happens if we do nothing. It's always an option to do nothing. Sometimes it's the simplest thing, but sometimes there's a real driver to do something as a result of it. So if we do nothing, this trust remains in play. Barry's entitled to the income of it throughout his lifetime, but on his death, everything passes to his daughter, Davina. There's inheritance tax on his death, and broadly £15 million at 40% is £6 million worth of tax. Additionally, Davina, who might be making bad decisions, then comes into £9 million, and who knows what she's going to do with it and whether that's the right thing for her and the family for the future. So what can we do about it to alleviate the situation? Well, the first things that spring to mind are, given that Barry's remarrying his childhood sweetheart, or marrying his childhood sweetheart, maybe we can do something whereby instead of everything passing to Davina on her death, instead it passes to Averil. And if she survives for a long period beyond Barry, then we can make gifts from Averil down to Davina in a sensible fashion that then avoids that £6 million of inheritance tax. And certainly I've seen occasions where we've been able to completely avoid the inheritance tax by making gifts early from a second spouse. Maybe we can put some form of variation into place in the existing trust. We can drop a life interest for Averil so that rather than things coming out of the trust, they remain locked in the trust wrapper itself, but Averil still gets access to the income on her death. And then we can take her life interest away in due course, making gifts again down to Davina, absolutely, or in some other form. Next slide, please. The ideal solution, well, To be honest, the ideal thing may well be just to get rid of the existing trust and start again. What that does is that allows us to rewrite everything entirely and create a new level of flexibility. Barry instead can leave his own will. He can make gifts in his lifetime. He can settle assets for Davina now. So this new house they're looking at, if they really do want to buy it, maybe they can look at buying it into a trust for her or into some other arrangement so that Davina is not troubled with having access to huge amounts of money that she might not do the right thing. Or if he wants to make sure that Averil is well looked after, it looks as if his side of the family is much wealthier than Averil's side, then he could put assets on his death into a trust for Averil to life and then leave it to the right beneficiaries thereafter. Why is this good? Well, if he takes advantage of the spouse exemption after he's got married to Averil, then leaving assets to her means there's no inheritance tax on that transaction, and then she can gift assets down to the next generation free of tax. The other advantage is that if there are gains inherent in the existing trust, they're wiped out when Barry dies, which means the assets go into trust, they've got no capital gains tax, and you can then give those away at that point with no further capital gains tax to pay. So potentially we can avoid all of the inheritance tax and all of the capital gains tax, saving the family up to about £6 million worth of tax overall. Something very worth considering. Next slide, please. So if we can do that, how do we go about finding out what we can do and how we can do it? The first step with these things is always to get a copy of the trust deed and to read it. The trust powers should be present, and hopefully they'll contain broad powers of advancement or appointment that allow us to effectively rewrite the trust, adjust it in ways that we need to take account of changes in the situation in the future. If those aren't there, then in Section 32 of the Trustee Act 1925, there are powers of advancement. Until 2014, they allowed you to play around with up to 50% of someone's life interest. Since 2014, it's been 100% for trust created after that date. So that gives us the flexibility often to do what we need. If there are, for some reason, issues in place, such as younger beneficiaries or other interests, then there's the rule in Saunders and Vautier, and what that says is if all the beneficiaries of the trust are over the age of 18, then they can join together and direct the trustees to do whatever it is they want to do anyway, and the trustees can't resist this. There's recent authority saying that trustees, even if they're trying to act in the beneficiary's best interests, can't countermand an instruction from all of the beneficiaries over the age of 18 together. We have seen situations where trustees have purported to restrict the beneficiaries only to those over the 18 in order to do things, or put themselves in a situation where this can be done. And as a general rule, that operation is something that's just completely void, is ineffective in law. And so instead you'd need to apply to court. That can get expensive, it can be troublesome, but it can give you a level of flexibility that you haven't got. The court has an inherent jurisdiction to vary trusts or to appoint new trustees or sack existing trustees. And therefore, at the end of the day, that's where you might end up. But the costs can be prohibitive. And so it's much better if the trust is drafted efficiently in the first place to give you sufficient flexibility to do what you want to do. And don't forget your taxes when you're looking at this. If you were to break up a trust, that's a disposal of all of the assets by the trustees and triggers the capital gains tax. Depending on the type of trust it is, it might be possible to hold over that capital gain into the hands of beneficiaries. That's if it's something called a relevant property trust, broadly one set up since 2006, or a discretionary trust. If it's an older style interest in possession trust, where all the income automatically goes to someone and it was set up before 2006, you normally can't avoid the capital gains tax, but you don't have to pay the inheritance tax. So you need to keep an eye on those, because whilst there might practically be a real desire to do something, there might be some immediate tax costs that you need to take into account and might indeed stall what you're doing or change your strategy. Next slide, please. The best thing to do is to get it right first time, to take full and comprehensive instructions, to understand not only what it is that the client is telling you they want to do, but actually what they want to achieve. Because often what they tell you they want to do isn't necessarily the best way of achieving what they're after. A trust needs to be flexible. It needs to take into account the circumstances change in the future. And whilst you might be set on doing something now, and you might think that your child is perfectly capable of looking after significant amounts of cash, you need the flexibility that if something happens to them, if there's an accident or an injury, or they have different needs in the future, the trust is flexible enough so that they're not forced to inherit significant sums at a time when they want to do so, don't want to do so. You also need to think about who the trustees are and make sure that they're the right people to make decisions in your absence. Sometimes I see people saying, can we just make all the children trustees together? And that's often the wrong thing to do, because what that will do is deadlock the trust. If any trustee disagrees with a course of action, then the trust can't do anything. And that's normally a bad situation to be in. And even if you choose good trustees to start with, who will act when those trustees are no longer around? Beneficiaries cannot benefit themselves generally under a trust. That means that if you are trustees of your own trust and you appoint your children in due course after you, that could cause problems because they can't give themselves benefits in the future. So you need to make sure that there's not only the right trustees now, but there are the right people in place in the future to look after things. Consider how much discretion you want the trustees to have versus forcing them to give people assets and income at certain times. And also think about how carefully the trust has been drafted. One of the big problems that we see is trusts that have just been knocked off a word processor from a basic precedent, and actually they don't do what it is the client thinks they did or what they wanted them to do. The real question here is I've been called by Emmett, who's a long-term client, who's talked about breaking up this trust. And the underlying question is, why does he want it broken up? Is there something else going on that means actually it's better for the trust to stay in place to protect Davina into the future, or is the right thing to do to get shot of it now? Dealing with trusts is a tricky thing. It's best left with the experts, but we're always happy to look over documents if people want a second opinion or want an idea about what's going on and how we might be able to help. Thank you very much. Next slide, please.
Good morning, everybody. I'm Justine Flack. I'm partner and head of the family team here at Howes Percival. Many thanks to Stuart for looking at the trust for us. Trusts are quite interesting elements of any divorce that comes up, so it's worth having a think at this point and having some understanding about what could happen to a trust if a relationship were to break down. So, as I say, trusts are effective means of asset protection. They're very effectively used in families as part of family succession planning. They have the benefit of tax planning so that those benefits can be taken advantage of and allow families to manage family assets. So that's all good. But as a divorce lawyer, you might ask why I'm interested in trusts. Well, many people believe that by putting assets in trust, they're effectively putting them out of the reach of the divorce court. So that when a marriage or a civil partnership breaks down, the divorce court isn't going to be interested in any trusts which are in existence. However, that's not strictly the case. So what is the situation on trusts? Next slide, please. Well, it depends what sort of a trust you're looking at. So firstly, you can have trusts which are defined as nuptial settlements. What is the definition of a nuptial settlement? Well, most helpfully, there isn't a statutory definition. So we have to look and see when does one arise to determine whether we've got a nuptial settlement or not. So a nuptial settlement will arise where you have a transaction transferring assets into a trust or setting up a trust, which is done in contemplation of a marriage. So that's an antenuptial settlement, or after its celebration. So that's a postnuptial settlement. So it's about looking at the facts which are in existence at the point the transaction takes place. Is the marriage a matter which the settlor has taken into account when making the settlement? That's a crucial question when looking to determine whether it's a nuptial settlement. That will give it the necessary nuptial, i.e. marriage element. So if you have a situation where a trust is set up after marriage and both spouses are beneficiaries, you've got the necessary nuptial element there. It can be harder to establish the nuptial element if it's prior to marriage. But what you're looking at is, are these transactions taking place, and has the settlement been made on the husband in the character of them being a husband, and the wife in the character of them being a wife? So you're very much looking at the circumstances around here and the fact that this is all happening around a marriage or because of a marriage having taken place. So what's the relevance if it is determined that this is a nuptial settlement that we've got in a divorce? Well, we look at section 24 of the Matrimonial Causes Act 1973, and that section allows the court to vary the settlement. So it allows a judge in the divorce court to order that capital is paid out of the trust to one of the spouses, generally the spouse who is not a beneficiary under the trust. They can provide for income to be made for that spouse. They can appoint trustees and remove trustees. So in short, you're giving the judge in the divorce court certain powers to meddle in the trust if you've created a nuptial settlement. And that can extend to things such as taking the matrimonial helm out of the trust and giving it to the other spouse. So if you have set up a trust to protect a certain property because it's a family property, and that trust is determined as a nuptial settlement, you could find that the property which became the matrimonial home which you set out to protect, the judge in the divorce court takes it out of the trust which you set up. So this can be very relevant, and it's important to bear this in mind where you're looking at trusts. Judges don't try and mess around with trusts if they can avoid it, so they will look at other assets and can other provisions be put in place by using other assets. They try and vary them as little as possible, and they have to take account of the other beneficiaries under the trust. But the fact remains that section 24 of the Matrimonial Causes Act gives judges in the divorce court quite wide powers to mess about with a trust that's been set up. Next slide, please. So if your trust is not a nuptial settlement, it's non-nuptial, what's the position then? Well, the good news is that section 24 of the Matrimonial Causes Act doesn't apply because it's non-nuptial, and so therefore the judge and the court has no powers against the trustees, so they can't meddle in the trust. All they can do is request the provision of information and documents. But that's not the end of it, because the Matrimonial Causes Act remains relevant, and we then have to consider section 25. Section 25 of the Matrimonial Causes Act is the section which guides the court as to the factors that need to be taken into account when looking at a divorce and the financial arrangements to consider what would be a fair outcome when a marriage is broken down. And under section 25, one of the things which it sets out is that the court must have regard to the income, property, and other financial resources which both parties have or are likely to have in the reasonably foreseeable future. And that's where trusts come in. The court will want to understand the position of the spouse who is a beneficiary under the trust. They'll want to understand the history of dealings, want to have sight of the trust deed, and know what the content of the letter of wishes is. So the court will make inquiries about the trust and what's happened with it. They'll want to know whether income has been paid out previously. What's been the involvement of the spouse who is a beneficiary under the trust? Do they have fixed rights? Remember, Stuart mentioned fixed rights under a trust. If they do, have those rights been supplemented by any discretion towards trustees? And if so, have the trustees used that discretion? Have they advanced capital? And they won't want to know, have the trustees just advanced capital to that spouse? They want to understand whether the trustees have a history of advancing capital to other beneficiaries, because that will give the court some guidance as to how the trustees may behave in terms of the trust. We often have situations where somebody is the beneficiary under a trust and the trust has paid out regular income to them. And what they often say to me is, well, the trustees are saying that they're not going to pay the income anymore. Is that, the right way forward? Well, the answer is no, because the divorce court will know full well that the reason why the trustees have decided to stop paying income at that particular point is because that party is going through a divorce. And what they will anticipate is that when the divorce is concluded, the trustees will start paying the income again. And that is the assumption that the divorce court will work upon. And so by not having the income, you're not really achieving very much. So even if it's a discretionary trust, if you've got any other sort of trust, please don't be under the illusion that the divorce court's not interested in it. It very much is. It will take account of it, and the way that it becomes effective, because of course it can't meddle in this trust, it can't introduce the other spouse as a beneficiary, but what it will work on the basis is that with judicial encouragement, the trustees will look after the spouse who remains a beneficiary of the trust. The reason that they do that is because trusts are usually set up, or often set up, to assist family members, particularly at times of difficulty. And of course, divorce can be a time of difficulty because you're in a situation where you've got to look after two households where previously you were only looking after one, and you usually don't have any greater resources to meet the needs of two houses that you had when you were meeting the needs of one. So the divorce court will consider that if the beneficiary asks, then there is a possibility, and sometimes a very good chance, that the trustees will look after that beneficiary and will advance assets from the trust and make sure that the family trust does look after them. That in turn can therefore impact the way in which the matrimonial assets are divided, because the trust becomes another financial resource which one of the parties has available to them. So therefore, trusts are important, and when clients are talking to us, then we need to understand and work out what sort of trust it is and have some understanding of the trust. So for Barry, if trusts continue, or if he was to consider that there would be a trust where Averil would be a benefit, and then that relationship didn't stand the test of time, then if there were a subsequent divorce between Barry and Averil, then we'd certainly want to know what had happened and what was going on with any of the trusts and what was their nature. Next slide, please. So might we have a plan B as far as Barry is concerned, which might be necessary if the trust is going to be broken up and the £15 million which sat in trust is now added to his £5 million. We still want to be thinking about what we might want to do in case the course of true love doesn't run true with him and Averil. And given the divorce rate, that's entirely possible that it won't. So what might we want to think about with Barry as an alternative? Well, plan B is a prenuptial agreement. So prenups, as you possibly know, are agreements which are entered into prior to the marriage and which detail the financial arrangements between the parties if the marriage should end. So they can be very powerful and useful documents in terms of giving some clarity to people and some understanding of what will happen in the event of the marriage ending as far as the finances are concerned. But more importantly, they allow us to protect and ring fence assets that one party may be bringing into the marriage. So what's their legal standing? Well, we currently don't have legislation which says if you have entered into a prenuptial agreement, then that will be determinative of how the financial matters are arranged upon your divorce. However, let's not forget our old friend, Section 25 of the Matrimonial Causes Act, because that comes into play again. Because Section 25 directs the judge and the court to consider all of the circumstances of a case when there is a divorce and to give certain weight to circumstances. One of the circumstances of a case which the court has to take account of if there is a divorce is if there has been a prenuptial agreement put in place. And what we often find is that where there is a prenuptial agreement, it has greater weight than other factors and other circumstances that the court will take account of. And so my advice to clients is always, if you are entering into a prenuptial agreement and it is being done properly, you can expect to be held to it. How do we make sure that it's done properly? Because if we're advising Barry, we'd want to make sure that we were doing a prenuptial agreement properly. So you need to comply with certain formalities which are set out on the slide there. One of the most important formalities is that the prenup is completed at least 28 days before the date of the marriage. This is often the formality which can cause the greatest problem when people phone me and explain that they're getting married. Do they need a prenuptial agreement? Yes, you do. When you're getting married a week on Saturday, they've sort of run out of time at that point. I might be a miracle worker, but I'm not quite that good. And so the prenuptial agreement isn't going to happen. If you've lost time, then you can deal with it as a postnuptial agreement. So you sort it out after the marriage has taken place. It is, however, better that we deal with it as a prenuptial agreement. So if anybody considers that one is needed, if someone's looking at a prenup, then the important thing is to think about it well ahead of the wedding. You want to be more than 28 days before the date of the marriage, because the last thing people want to be thinking about when they're about to have one of the happiest days of their lives is the legal terms of a prenuptial agreement and what might happen if it all comes to an end. People have got better things to be thinking about at that point, and it can be very pressured if they are considering the terms of a prenup that close to a wedding. So the further in advance you can do it, the better. It's important that there's disclosure so we understand what people's assets are and what they want to protect. So we already know with Barry what his situation is. In fact, on discussion, it might become clear that there would be some benefit to Averil of having a prenuptial agreement, because she might have certain assets that she wants to keep out of the pot on divorce as well. Ideally, we want both parties to get legal advice. We have to consider fairness. So the terms that are being agreed, are they fair? And also it's important to have review clauses in there because people's circumstances change as life goes on. Basic way in which we tend to deal with prenups is that we categorize our assets into separate property. So that's stuff which is non-matrimonial that people are going to keep separate if the marriage ends. So it's basically I brought it in, so I'm taking it out. And then other assets which are joint property. So they're matrimonial and they're subject to sharing. So we tend to deal with them in that way. They are much more complicated than that, but that's a broad overview of how prenup works. They are very useful, as I say, because they bring clarity and they allow protection, which otherwise isn't guaranteed under the divorce court. People often ask me about the cost. No, they're not cheap documents to draw up, and really nor should they be. They are complex, and if you're wanting to protect assets, it's important that it is done properly. What I say to clients is to consider the value of the assets that they're wanting to protect. So I've recently done a prenuptial agreement for a client. The costs between myself, the lawyer on the other side, the barristers who were used because of the complexity of it exceeded £30,000. And I'm sure there's been a sharp intake of breath there at that cost figure. However, the value of my client's estate and the assets that we were wanting to protect were over £100 million. Even by my maths, that's 0.03% of the value of his estate. And I think he thought that that was money well spent. It's worth spending money to get a prenuptial agreement done correctly. Generally, your prenuptial agreement will cost less than a divorce. But it's not just the financial cost, it's the emotional cost that goes with a divorce. People often say to me, prenuptial agreements aren't romantic. I agree, they're not particularly, but then I've yet to be involved in a romantic divorce either. Next slide, please. Thank you. So just one final issue to look at connected with Barry is that we heard that he is considering advancing some money to his daughter, Davina, who wants to buy a house in Exeter with her boyfriend, who people aren't entirely certain about. How do we make sure that Barry's money is protected? Well, first of all, it's important that Davina thinks very carefully about how she and her boyfriend are going to hold the property as it's going to be bought in joint names. There's two ways of holding property in joint names at law: joint tenants or tenants in common. In Davina's case, that she would need to hold the property with her boyfriend as tenants in common, because that keeps their interests very separate. So in the event of Davina's death, then her money that she's putting in, whether that's her own or coming via Barry, is kept separate from the boyfriend. He doesn't automatically inherit. It's also important in case the relationship breaks down, because it's very clear then what her interest in the property is, and usually she would hold as tenants in common, and that would be supported by a declaration of trust setting out exactly what her interest in that property is. From Barry's perspective, he should also consider a formal loan, which could be secured upon the property. So we've got some very clear documents about money which Barry has passed across or given to Davina, so that we're very clear that if anything were to happen in the relationship between Davina and her boyfriend, that money would need to come back to Barry if that was what he wished to happen. From Davina's perspective, she might want to consider a cohabitation agreement. That's an agreement between parties who live together to determine the arrangements between them. Obviously, it's crucial that boyfriend is in agreement, because it is a cohabitation agreement. So if he says, no, I'm not entering into that document, then we can't force him to do so. It can be useful because it sets out what the terms of their living together arrangements are, and therefore it can persuade people not to bring proceedings under the Trusts of Land Act in the event of a relationship breaking down. So it would protect Davina in the event that the relationship with the boyfriend broke down and he tried to claim that he'd got a greater interest in the property for various reasons. So it's protective of Davina, and it's something that she ought to consider. And my final word is a word about the common law spouse. Davina is going to live with her boyfriend, and there is an assumption by many people still that after a certain point in time, Davina and her boyfriend would be treated as husband and wives if the relationship were to break down. So although they hadn't got a marriage, because they'd been together for a certain period of time, one of them would assume the position of common law spouse. That's complete nonsense. The common law spouse is a bit of a mythical beast, but many people still think it exists. And in fact, this weekend, someone asked me about it, and they assumed that there was a common law spouse. I've been asked over the years whether a common law spouse arises when someone has lived with another party for 6 months, for 2 years, for 7 years. I've heard of all sorts of timescales, but it's irrelevant. The law for people who live together is very different from the law when people are married. So Davina and her boyfriend would not become common law spouses, even if they carried on living together. I'll now hand over to Jenny.
Morning, everyone. I'm Jennifer Lasky. I'm a contentious probate specialist at Howes Percival, and my job really is to deal with challenges to wills and estates when people die. It involves really knowing what the picture is for a jigsaw puzzle, but having none of the pieces and having to go around and find them. So for our purposes, with our case study today, picture the scene where in fact Barry's gone and made his will with someone else, not Howes Percival, because we've done it properly, but he's gone for my purposes to a will writer who's drawn up a will for Barry, and the will itself really is along the lines that Everett wanted it to be. And the will is sent out to Barry for him to sign with some pretty vague instructions. Barry signs the will, and later on Everett takes it round to the neighbours and it's witnessed. I come into the scene when unfortunately Barry dies, and Davina finds out that her father has left her out of the will. She's very upset about this. Next slide, please. So there are very few reasons for overturning a will, and generally the courts will do all they can to defend the testamentary freedom of a party who's made a will. It's not as easy as knocking over dominoes to prove that a will is invalid, and these grounds on the screen are the ones that we could rely upon, some of which people have already touched upon. So the will is not properly executed is one of the grounds. The person who made the will lacked the requisite mental capacity at the time when the will was made. Rebecca talked about that earlier. She also talked about the fact that a will be invalid if you can show that there was undue influence and the person was coerced into making the will in the way that they did. A will be invalid if the person who made the will didn't know or approve of its content. There are odd cases where people don't actually know what they've signed and didn't appreciate they were perhaps even signing a will sometimes. And in that case, a will could be proven to be invalid. Wills will also be invalid if you can show forgery or fraud. But the mere fact that you don't like someone's will, I'm afraid, is not enough to get rid of it. I spoke to a client just the other day who's very aggravated. His father has made greater provision in the will for his brother than he has for my potential client. And this really sticks in his craw because his father has previously helped out the brother with not just one lot of wedding costs, but two. Whereas when my client got married, his father was far less generous. Sadly, in that case, my advice has got to be, well, Dad can do that, because if I can't show any of the factors that are on the screen at the moment, then Dad is free to make as unfair a will as he wishes to. And so that will likely stands. So the good news is that if you make a will properly, if you take steps to protect your assets, you can potentially save tax, and you can provide for the people that you want to provide for. And the will is likely to stand. Next slide, please. I'm going to look at witnessing a will and a failure to witness a will properly. I don't know how many people here today will have ever been asked to witness a will. It's a pretty straightforward act. You just sign where you're told to. You don't need to know what the will says. You don't need to know anything about the content of the will or who's getting what. And it's not an obligation on the person whose will you are signing to tell you any of that information. But what you do need to know is that the person who is saying it is their will, it is them. So you need to witness their signature. And importantly, the will has to be witnessed by two people who are present when the testator signs or acknowledges their signature. So a person doesn't necessarily need to see the testator sign the will to be able to witness it, but the testator does need to prove and say that it is their signature and ask the two witnesses to witness it. The best witnessing of a will, of course, is that the person signs the will in front of two witnesses who then also sign the witness sections of the will. Now, this would seem to be perfectly straightforward. You probably can't get witnessing a will wrong. Well, actually, you can. So let's take two real life examples. Next slide, please. The hospital signature. So I was instructed by a lady whose husband very sadly had been dying. And of course, by the time she came to see me, he had in fact passed away. When he was in hospital, not really expected to last the night, his family were there with him, and they did not like my client, even though she'd been married to him for a number of years, and they had a child together. And so the family drew up a will for the dying man, which left the entirety of his estate, including the house my client and her daughter lived in, to his sisters. When she came to see me, really, we were thinking that we needed to make out a claim under the Inheritance Provision for Family Independence Act 1975. And so we'd have to have a fight with the family for reasonable financial provision for her. But in fact, when we investigated the situation, we found out that the dying man had been absolutely dosed up on morphine at the time the will was made. He didn't really know what was going on. We could have gone with lack of capacity, but in fact, we did have an easier route, and that was this. He signed the will in the manner of someone putting the pen in his hand, squeezing his fingers shut around it, and then moving his hand on the will to effect a signature. The first witness was actually doorstepped as he got out of the lift to visit the dying man, so he was nowhere near the testator when he signed the will, and he witnessed it in the doorway of the lift. And we discovered from nursing records that the second witness had witnessed the will later on in the evening, but the testator had been asleep in the hospital bed at the time. So rather than having a massive fight and making a claim under the 1975 Act, we were able to show that the will was invalid for lack of due execution. And in fact, there was an intestacy. And as a result of that, my client, the wife, inherited everything in the estate, which was reasonably modest, and managed to keep the matrimonial home and that roof over her daughter's head. Next slide, please. The car park signature. This was a situation where a lady in later life had met a very attractive foreign man who had fallen madly in love with her and she with him. And she had assisted him to come back to the UK where they'd lived together. I was approached by this lady's daughters, and they were very concerned. Mum had in fact by then lost capacity and she was in a care home. The boyfriend hadn't been to visit her in over a year, but in going through some of her papers, they had found the will that she had made, and the will cut both of my clients, both of the daughters out and left everything to this foreign gigolo. And what we were able to establish was that he had written the will, and their mother had, when she had capacity, signed it, but he'd then taken the will to his place of work, where one of his colleagues had been the first witness, and he'd subsequently met the lady's best friend in a country park car park when she was on her way to go and walk her dog, and she'd literally put it on the roof of her car and signed the second witness statement signature there. So again, we've got a situation where the will hadn't been duly executed because neither of the witnesses had seen the testator sign the will. Now, in that case, the lady was still alive, so we could have made an application to the court for what is known as a statutory will to be written. That's a will where someone has lost capacity and the court will write your will for you. But it is quite a complicated process. It's quite expensive and it can take a reasonable amount of time. In our case, we decided just to wait. So we got witness evidence from the two witnesses as to the circumstances in which they had witnessed the will. And we sat back, and about 2.5 years later, the lady sadly died. And we were able to produce that evidence as evidence that the will was invalid, again, for lack of due execution. So it's another salutary tale about the importance of getting the witnessing of a will right. In that case, that worked well for my clients. They were the lady's daughters. Her previous will was valid. And under that will, before Gigolo had come along, they inherited everything. But that is potentially just a logistical difficulty in witnessing wills and people not understanding the rules and regulations. What about more sinister family plots? In our case, actually, Everett's been up to no good. You've heard my colleagues explain that there's this suggestion that Davina is perhaps not making her living in the way that everyone would wish. Everett suggested to Barry on a number of occasions that Davina and her partner are in the brothel business. There's a question about how she finances the holidays that she takes and the cars that she drives, and the suggestion that this new property they want to buy in Exeter is actually just an extension of their business interests and an opportunity to install more workers in yet another brothel. And in our scenario, Barry is not a fan of prostitution. He doesn't agree with that lifestyle and means of earning a living. And he's very concerned that Davina should inherit and use the money in this way. So he leaves her out of the will. And of course, absolutely none of this is true. Everett made it up. This is more than undue influence. Next slide, please. This is what is known as fraudulent calumny. Fraudulent calumny is this idea of a poisoning of the mind. So it is more than just a bit of pressure to leave someone something. It is the idea of an intentional poisoning of the mind so that a natural beneficiary is left out of a will. And you can see on screen one of the definitions from Edwards and Edwards case in 2007. And if you can show that on the basis of a poisoning of the mind, the testator has left out someone who would otherwise be a natural beneficiary, then the will be liable to be set aside. You need to have more here than just gossip. So if you are passing on gossip you honestly believe to be true, that will not be sufficient to be fraudulent calumny. It has to be a knowing poisoning of the mind, an intentional passing on of information that you full well know to be false. Next slide, please. Although in our case study, you might think we've gone a bit over the top, really suggesting that Everett has planted the idea in Barry's mind that Davina's running a brothel. In fact, you're looking on the screen at a nice chap called David Whittle, who was in real life the subject of just such a ridiculous plot by his own sister. So in the case of Whittle and Whittle, which was actually decided earlier this year, David Whittle was able to show that his sister had persuaded their father that he was abusive to women, that he had stolen money, that when the father had been in hospital, he'd been in the house trying to find out information about father's finances, and that he'd lived off immoral earnings, if you can believe this, by prostituting his own wife. And unbelievably, the father had believed all of this, fallen for all of this, and had cut David out of the will. So the case actually ended up in court, and David Whittle was successful in showing what his sister had been up to. Now, of course, part of the problem with my line of work is that usually my key witness is deceased by the time anyone actually approaches me. So in our case study, happily, Barry has been confiding in one of his golf buddies. And so we're able to find the evidence that it's Everett who's been using this drip, drip, drip approach to plant the idea in Barry's mind that Davina is involved in improper actions and operating a brothel. And so either by means of showing that the will hasn't been properly witnessed, because Everett took it round to the neighbours to be witnessed, or by showing that Everett has planted bad ideas in Barry's mind and is guilty of fraudulent calumny, we're going to be able to overturn this will, and we'll be able to go back to a previous will under which Davina inherits. So I hope you can see from that, my job is to help people to get to the result they should have been in if a will had been properly made. If all wills were made properly, I would be out of a job, and really that's should be the ideal for everyone, because if a will is made properly, if proper advice is taken, then it is very, very difficult to show that it's invalid or to overturn it. As Justine said when she was talking about prenuptials, wills can appear to be expensive. No end of clients will try and get an off-the-shelf pack from W. H. Smith or whatever, or write one themselves, Google how to write a will. Wills are not expensive. Paying tax you could have mitigated by making a tax-efficient will. That's expensive. Challenging a will is expensive. Recovering your rightful inheritance, that's expensive. And as Justine said, the cost of making these claims is emotional, not just financial. If you were in a situation where a parent or a sibling or another loved one, a spouse, has died, and rather than being able to grieve and work out how on earth you go on from here, you're forced into a legal challenge to try and recover what should otherwise rightfully be yours, then that is an extremely difficult situation to be in. And it is going to be also your bank balance that takes a hit, because lawyers are expensive. So the cost of making a will properly in the first place cannot be, it's just worth its weight in gold. So the best advice that any of us would give to any client is to try as hard as you can to put lawyers like me out of business, make a will properly, and go to someone who actually knows what they're doing. I think that that's the end of our presentation. So if you've got any questions, please put them in the Q&A at the bottom, and I'll hand back over to Tom.
Jenny, thank you. and also thank you to the rest of our speakers. I should just say that we are going to be circulating a copy of the slides from today together with a recording, which will follow by email later on today. So on to the questions, and thank you. We've had some very interesting ones. The first one is to Rebecca. Rebecca, what happens if a client loses capacity during a transaction?
Thanks, Tom. So that's an interesting one. If a client should lose capacity, or we suspect that they've lost capacity during a transaction, effectively the transaction needs to halt until we've ascertained the position and checked whether we can continue to accept instructions from the client. So the first thing we need to do is decide if the client has actually lost capacity. So we will go back to the tests that we discussed earlier, and we will make our own assumptions. If we need medical evidence at that point, then of course we will obtain that also. If we're happy that they have lost capacity, we may still be able to continue in the transaction by accepting instructions from a third party. That third party would depend on the type of transaction and the legal arrangement that we have in place. So it could be, for example, with a property transaction, we might have a power of attorney in place, either an enduring power of attorney or a more recent lasting power of attorney. So we may be able to accept instructions from the attorney appointed under that legal document. In the absence of a power of attorney, we might be looking to the court to appoint a deputy. So it's the Court of Protection, which is a specialist court that will appoint a person known as a deputy to administer that person's property and financial affairs. If it's a litigation matter, then a litigation friend may be appointed by the court also. But it's important to note the potential legal consequences that if we did continue with a transaction where we suspected or knew that a client had lost capacity, there could be a subsequent challenge and a transaction could actually be set aside by the court. So it's really important that people are on top of this and aware that it will affect a transaction.
Super, thank you. Jenny, one for you. If you think a will is invalid, what should you do?
Oh, you should come and talk to me is the answer. Well, the first thing that you can do, and it's unbelievably easy, is to lodge what's called a caveat. You can do that. There's a government website where you just literally follow the links. It says start now and you just fill in the boxes. A caveat is a formal stop on a grant of probate being issued. So it stops anyone getting a grant and being able to deal fully with the administration of the estate under the will in question. Unbelievably to me, you don't have to give a reason for a caveat. They are badly used by a number of solicitors in my view. I've got one at the moment where the solicitor on the other side has lodged a caveat because they say the estate owes them some money. That's not the right reason to lodge a caveat. But if you think the will is invalid, if you think actually there is a will and someone's saying there's an intestacy, so they're going for a grant of letters of administration, or if you think there's a later will and the wrong will is being produced, you should lodge a caveat. It costs £3. It's really quick to do. It will last for 6 months. It will place a stop on the probate being issued, and you should use that time then to investigate whether there is a later will, whether there is an intestacy, whether the will was validly executed. And the way you do that is you go and talk to me.
Super. Thanks, Jenny. Absolutely agree with everything you say there about caveats. Stuart, question for you. What can you do in your will if a second spouse doesn't get on with your children or vice versa?
It's a surprisingly common thing that you see. You want to make sure that your second spouse is well looked after for the remainder of your life. Their kids get desperate to get their inheritance and they don't get on with each other. What you don't do is all make them trustees together. Again, as I mentioned earlier, that can deadlock the trust. You need to make sure that the right people are in place, which might need professionals, to make sure that funds are available for the surviving spouse to look after them for the rest of their lives, and that the kids get the right inheritance at the right times. Sometimes there are tax benefits that can come from that by putting additional assets into the trust for the spouse and then taking them away early, but it's something to be very, very carefully managed. The real thing that you do want to come out of all of that is a very clear letter of wishes for the person who's died, setting out what they wanted to happen, so that if there are professionals involved, they've got something to refer back to say that this is what we're doing, this is what they wanted us to do, and therefore we're proceeding on that basis. And generally the courts, if there are ever disputes, support professionals who are acting in accordance with those sorts of letters of wishes.
Super. Thanks, Stuart. Justine, one for you. If Davina was married rather than living with her partner, would Barry still need to formalise the arrangements for giving money to help her?
Yes, it's really important. We often have situation, we refer to the bank of mum and dad. Parents are very keen and willing to assist their children, whether that's in the purchase of a house, buying the dream home, or assisting with businesses. If it is not properly recorded how that money is being given and a marriage breaks down, it is very surprising how people's recollection of events differ. And one person will say it was a loan, the other party will say, no, it wasn't, it was a gift. And if we've got no documents or formal arrangements which tell us what it is, then what we often find is that the parent who has provided the money has to become an intervener within the divorce proceedings of their child. That's horrendously expensive for all concerned, not just in financial terms, but emotionally. And we have had situations where we've had some very elderly parents having to become involved in the divorce proceedings of their children. We wish to avoid that as much as we can, and so therefore making sure that it's all clear, it is really important, and evidence in the divorce court is vital, because otherwise you end up with a situation of the court having to work out whether they consider it as a soft loan, which is likely to be disregarded, or a hard loan, something that's got to be taken account of in the division of assets.
Super. Thanks, Justine. I'm conscious of time and getting everyone away sharpish. So this will be the last question. If we haven't got to yours, apologies. We'll follow up directly with you and answer those questions that remain. The last question is to you, Rebecca. What are the red flags for capacity that practitioners should look out for?
Okay, so there's many that we would look out for when seeing a client. The first one is obvious. If they are particularly forgetful, like in Barry's case, we will see that as a red flag and want to know a little bit more about that forgetfulness. Is it just because they're nervous in the meeting, or is there something going on behind the scenes? Similarly, a vagueness. If they're particularly vague when we're asking them questions, is that because they're embarrassed and they're forgetful, so they don't want to answer the question, or again, is there something more going on? If there is always a referral to another person to answer a question, so if they're in the meeting with somebody, like in Barry's case, he was with Everett and he was looking to Everett to answer a lot of those questions for him, that can again sometimes be a reluctance to actually answer questions because they're embarrassed because they don't know the answers or they can't remember the answers. Likewise, if we receive instructions from a third party, sometimes we're contacted by son or daughter of mum or dad, and they start trying to give us all of the instructions to prepare a will or power of attorney. Well, of course, we need to make sure that we're speaking with the client. If the client's going off at a tangent in the meeting and the conversation really is not very relevant, that's a key one. If they are particularly repetitive and they keep repeating the same things to us, and it will really go on from there. It could even be their appearance. If we've seen this client on more than one occasion and their appearance changes significantly, if they're particularly dishevelled or weight loss, or there's a reason that we think that something's not quite right. So there's lots of things we would look out for. They're just a few.
Super. Thanks, Rebecca. Thank you once again to all our speakers. Thank you again to everyone attending. I hope you found the session very helpful. I'm getting you a minute ahead of time. I'll now formally bring the session to a close. Many thanks all.